Good afternoon, all. This application hearing is in the matter of CFI 063-2024 before His Excellency Justice Shamlan at Sawalehi. The claimant is represented by Mohammed Al-Dabashi. Advocates lead counsel is Mr. Tom Montague Smith, KC. The defendant is a litigant in person, represented by Mr. Hussein Ayachi. Thank you, Your Excellency.
Yes, thank you.
Good afternoon, Your Excellency. With your permission, this is a claim under the terms of a contract for the sale of bonds. The court has already found the defendant liable for breach of that contract, and the only question for today is how much they should have to pay. Your Excellency, we would suggest that this is a relatively straightforward question, and the answer is 6.5 million euros plus interest plus costs, because we say the bonds are worthless. We have filed some evidence, and Your Excellency has a skeleton argument from me. I don't know whether you've had a chance to read the skeleton and the witness statement and the expert report. That's very helpful, thank you. The defendant has not filed any evidence. The defendant asked for an extension of time to file evidence, was granted it, asked for another extension of time after the time, didn't file anything, and then yesterday was ordered to file urgently a skeleton argument and hasn't filed anything. Nevertheless, we have Mr. Hussein, who I understand intends to make some submissions on behalf of the defendant today. I don't know how Your Excellency would like to proceed. I think we have two witnesses to call, and so I was going to tender those witnesses, and Mr. Hussein can ask them any questions, and Your Excellency can ask them any questions that you have, and then we could get into the submissions subsequently, if that's convenient for you. Yes, absolutely. I'm very grateful. All right. Well, the first witness is a witness of fact, and it's Mr. Oleg Jelesko. He ought to be online, and I would ask Mr. Jelesko, please, to turn on his camera, and we will call him first. I don't know whether or not the registry will administer the oath, or you'd like me to do that. I'm in your hands.
Either both. I'm fine. Registry.
Yes, Your Excellency, I will proceed to administer the oath. Can I please confirm whether you are going to be swearing in by oath or affirmation?
Mr. Jelesko,
affirmation, please.
Thank you. Please confirm your full name and occupation for the court's record.
My name is Oleg Victor Jelesko. I'm a director on the board of ISTAR Capital. I'm also a managing partner of Da Vinci Capital, which is a Guernsey-based investment management firm.
Thank you. Please repeat after me. I affirm that I will say nothing but the truth.
I affirm that I will say nothing but the truth.
Thank you. Thank you, Your Excellency.
Thank you.
Thank you. Mr. Jelesko, you should have a copy of your witness statement in front of you. Can you see that?
Yes, I have a copy of my witness statement.
Thank you. And for Your Excellency's note, it's at page 21 of the bundle.
Okay.
And Mr. Jelesko, can I ask you, please, to turn to the end of that statement? Your Excellency, it's page 40 of the bundle. And do you see there your signature?
Yep.
And can you confirm that the facts stated in that witness statement are true?
Yes, I confirm that the facts stated in the statement are true.
Thank you, Mr. Jelesko. Your Excellency, I didn't propose to ask Mr. Jelesko any questions. I don't know whether you have any questions for him. Maybe we should see whether Mr. Hussein has any questions for him.
To be honest with you, for me, it's very straightforward, but unless if the respondent want to examine the witness. Yes. Respondent.
Mr. Hussein, that's a question for you. Have you got any questions for Mr. Jelesko?
Well, Mr. Oleg, I just want to ask you, is there a settlement now going on? And was this supposed to be cancelled or not? This court settlement?
Yes, there is a settlement that is going on where Lars Windhurst, which is your friendly counterparty, he arranged these trades. He is trying to settle this. The trades taking place right now in London through a broker. The partial amount was traded. We haven't received the money yet, and there's another amount that is traded as we speak, but I haven't received any confirmation. It's all frankly last minute, and I feel a bit embarrassed because but I have to tell you the truth. Yes, there are settlement ongoing right now. We haven't received the money yet. And we did have a request to cancel this hearing last minute, and I just have not been able to instruct the lawyers, and this trades have not fully settled yet or not entered into the system. I just would like to be very transparent about this case, and the court should know this as well.
May I have a question to the judge?
Sorry?
Can I have a question?
Mr. Hussain,
Okay.
at the moment, the process is that we deal with the witnesses first. So if you've got
okay,
anything
sorry.
further you'd like to ask
Sorry.
with Mr. Jalesko, then please.
No, that's it. That's it.
So Mr.
you.
Jalesko, just to re-examine on that, because that's news to me as well. So your position at the moment, as I understood your evidence, how much money, how much has been provided to you in relation to these bonds?
Well,
today?
The current consideration that it was all last minute because our one of our brokers in London was contacted by a counterparty representing, I guess, a related party to the defendant, and the first amount that was traded was €3 million for ISTAR to sell the bonds to our London broker and receive consideration. And there is a second amount promised, €2.55 million, which would most likely, if both amounts are settled, 2.55 and 3 million, that would complete our claim, and we would withdraw from any further claims towards the defendant. But as I would like to emphasize, this was all last minute. We had to verify the KYC, our London broker, and we did confirm the first trade with the T+5. Sorry for the technical jargon. Apologies for this. And T+5 settlement, meaning that the cash is likely to arrive in 5 days, and the same broker representing the parties friendly to the defendant is, I believe, trying to enter the second trade into the system for 2.55. If both trades settle within 5 days, we will have no further claims to AUDACIA, and we'll consider this case dismissed.
Well, I think this is the matter for enforcement later on after this
I
court.
agree.
Yeah. Okay.
We can deal with that in submission, Your Excellency. Thank you very much. Any further questions for Mr. Jalesko? No.
Not for me.
Grateful.
Not
Thank
for
you.
me.
And I just for the sake of form, I better call Mr. Girard, please. So, Mr. Jalesko, you can turn your camera off, please.
Okay.
Mr. Girard, please could you turn your camera on? Thank you very much. And the registry will administer the oath to you.
Thank you. Please confirm whether you are going to be swearing in by oath or by affirmation.
By affirmation, please.
Thank you. Please confirm your full name and occupation for the court's record.
My name is Maxime Girard. I'm a partner at HKA Consulting.
Thank you. Please repeat after me. I affirm that I will say nothing but the truth.
I affirm that I will say nothing but the truth.
Thank you. Thank you, Your Excellency.
Good afternoon, Mr. Girard. Thank you very much for joining us. Could you please tell me, do you have a copy of your expert report in front of you?
I do have an electronic copy of the bundle, which I'm...
Oh, you do.
Right.
Thank you very much. If you could turn, please, to page 506. Can you tell me, is that a copy of your report?
Yes.
And then, please, to page 525.
This
Do you
is
see
my
there?
signature.
That's your signature. Thank you very much. And can you confirm that the contents of the report represent your true and complete professional opinion?
I confirm.
Thank you very much. Your Excellency, sorry, Mr. Hussain, probably first. Do you have any questions for Mr. Girard?
Yes, Mr. Hussain.
No, thank you.
Thank you. Your Excellency?
No, I don't have anything.
Thank you very much. Very good. All right. Thank you very much, Mr. Girard. That's that you're released. I'm grateful for your time.
Thank you.
So, Your Excellency, Mr. Hussein obviously has told us, and Mr. Jalesko has been very frank with us that there are payments that are on their way. As at today's date, nothing has yet been received. So my position is that it doesn't actually change things. It may well be that the parties can reach some resolution subsequently, but it doesn't stop Your Excellency from saying, as of today, this amount is due and entering a judgment. So that's what we would ask you to proceed with. So with your permission, I was just going to make my submissions on that as quickly as I may. So we say, as I've said, that the sum which should be awarded is €6.5 million plus interest, and you can get there in a number of different ways, but they all lead to the same result. The first point we make, and we make this in the skeleton, is that this is just a debt claim. They promised to pay €6.5 million. The time for payment has passed, so they need to pay. Now, that is a bit different from a damages claim, because it's just a claim for a sum, a promise to pay a sum. And it may be said that is not quite the way that it's put in the documents. But if we say, if you approach this as a damages claim, you get to the same result. And one might ask, well, what's the difference? The difference is just that a debt claim is just a claim for money due under a contract, and in a damages claim, the money may not yet be due, but the parties might say, for example, I'm going to deliver the goods to the other person, and when I do deliver those goods to you, you then promise to pay me, but the deal is cancelled before they deliver. And it makes a difference if the goods or the thing that's being sold has some value. If it's a debt claim, I'm just entitled to the money. If it's a damage claim, my damages are what I was promised, less what I'm left with. You will have seen that the background to the contract is set out in Mr. Jalesko's statement, and I won't. We summarise it in my skeleton argument, and you'll have seen that the idea was that my client would acquire these bonds in a company called from a company called Voltaire, and then sell them on to the defendant. And as Mr. Jalesko has explained, the deal was introduced by a man called Mr. Windhorst, who is the owner of Tenor. And the story that my client was given was that Tenor wanted to buy back these bonds and had to do it indirectly, otherwise the price would go up. If you want to see that, you can see that at paragraph 22 of Mr. Jalesko's witness statement on page 26. But the point is that Mr. Windhorst ultimately owns Voltaire. So this was a means for him to consolidate the bonds. And the deal was going to be done via the defendant. So the claimant and the defendant entered into the contract, and you can see the contract. I'll just show it to you briefly. It's on page 47 of the bundle. So you'll see that the parties' names, and you'll note that the name of the claimant has changed slightly since that date, but from ISTAR to ISTAR. But you can see in the middle of that page 47 what is being bought and sold, up to 65 units of the bonds, of the securities, and each security is 100,000 euros, and that's why we get to 6.5 million euros. And then on page 48 of the bundle, paragraph clause 3.2, you can see the payment terms. And there are 3 stages, and it says that the stages are to be completed, clause 3.2, in the order set forth below. That's the underlined bit. Stage 1, the seller shall deliver to the purchaser a trade confirmation. Step 2, the purchaser shall pay the consideration. And then step 3, the seller shall deliver or make available an executed stock transfer form for the securities themselves. So the claimant went ahead and bought the shares and presented the confirmation, and you see that on page 60.
Yes.
And so that's the first stage, and what should have happened then was payment, but of course nothing happens. And so on the next page, page 61, a notice of default was sent. The defendant then sent a couple of their own trade confirmations, and you can see those on page 63. It's not clear why they did that, 63 and 64, and then they sent a couple more on pages 66 and 67. There's no contractual need for that, but there it is. But one way or another, they never paid. So my client was left with the bonds, but did not receive the price. Now, there have been further broken promises. There was a settlement agreement previously. I don't know whether you've seen that. It appears at page 1413. We don't need to go to it, but a promise was made to pay under that, and nothing happened in relation to that. And so it is perhaps a little bit unsurprising that last minute flurries of activity don't mean that this is the end of the claim. We've been here before, but it does look promising that we will get some money eventually. The problem is that the bonds are themselves worthless, we say. They were supposed to mature, and so the issuer was supposed to pay them out on the 26th of July 2023. So they're coming up to 2 years in default, and the claimant has tried to sell them, but nobody wants them. And I'll show you that at page 30 of the bundle. That's in Mr. Jalesko's witness statement, where he recites some correspondence with some traders with whom he tried to place the bonds. So there's three brokers were approached, and each of them said, we're not going to pay you for these, so we don't want these because they're bonds in default. So the market doesn't want the bonds. The bonds cannot be enforced either by my client. My client has about around 3% of the bonds in all of this. But if you want to enforce the bonds, you need at least 25% of them, or you need to group up with people who have at least 25% of them. And that appears in clause 3.3 of the bonds, which you'll see on page 72. And what that requires is if there's an event of default, then 25% of the holders need to approach the security trustee, and it's only then that the security trustee, in their discretion, may seek to enforce the bonds. And the difficulty is that 75% or more of these bonds are held by Tenor and Mr. Windhorst, who ultimately own the company in the first place. So they would need to take action effectively against themselves in order to actually enforce the bonds. It also appears doubtful that Voltaire could actually pay out on these bonds even if there was enforcement. So the result is that the claimant has not received the 6.5 million. It has bonds it cannot sell, and there's no way to realise them, and so they're worthless paper. As I mentioned, the court has already found the defendant liable for this. I can show you that very briefly. That's on page 14. Justice Mahal Meheri has found that, so that's clause 2 of that. The defendant shall pay the claimant damages to be assessed. And so the assessment of quantum, we say, is pretty simple. First, there is a debt. Clause 3.2 of the contract says payment was due on presentation of a deal confirmation. That was presented and nothing was paid. I point out it's not pleaded that way, and that's not the way that the judgment was entered. The judgment was entered for damages, not for a debt. So it may be that you're not comfortable with finding that, and it may be said the court should go on and assess loss. So what's the loss? This is an English law contract, and I've set out a bit of the relevant law. I don't know if you got my skeleton arguments. I won't labour it because I want to allow you to move through this as quickly as possible, but it's section C of my skeleton, and it may be that we can do any bits of the law by reference to that. So the position is this. It's not terribly complicated, and we get the rules from sales of goods cases. If I agree to sell someone some goods and they refuse to take them, I will usually get the price that we agreed less the market price of the goods. So if you sell me rice for $1 million and I cancel the deal, and there's an available market for your rice, but it's only worth $750,000 on the market, you can sell it into the market, but then you come to me for the difference. That's the issue. But you need an available market. And so if there's no available market, you have to value the loss slightly differently. The test for whether there's an available market, we can see my skeleton paragraph 31. I recite some of the relevant bits, but what there would need to be is a market there's sufficient demand to absorb readily all the goods that are thrust upon it. So if you have, say, shares in HSBC Bank, those are listed, I can sell them. So I can go to the exchange. These are not listed securities, so we have to offer them to the market individually. It's called over the counter, and we've done that. I've shown you that. No one wants them. And then I've quoted a passage from Lord Justice Gross, as he was in the AirCap case, where he says, paragraph 32 of my skeleton, if the goods are offered for sale and there is no buyer at a fair price, it's difficult to conclude that there was an available market at the time in question. So it's pretty straightforward, really. Where there is no available market, the loss is usually the price agreed less the price that's actually achieved. And I've put in a couple of sections from Chitty. There's a passage from Claimant. I don't know whether you'd like me to show you that. I know you're.
No. I know those paragraphs. So
I'm very grateful.
Just a record, yeah.
So the starting point is that if you don't get anything when you try to sell them, then that is the best guide to the value, the zero. But in addition, we've got Mr. Girard's evidence.
Yes.
So we say all roads lead to the same answer. The loss is the price. And there's no way of mitigating in the sense of actually enforcing the bonds, because as I've said, there's no way of actually getting payment under those. They're long in default. They require 25% ownership. And Mr. Girard has also gone into a bit of depth about why the bonds don't have any value. Just to show you that very, very briefly, if you go to page 512, you'll see 2.2.3 of his report. He says there's just no value there's no value in a resale from these. And 2.2.5, he says Voltaire's only main asset is a company called Wild Bunch. And then over the page on 513, in the bullets, just in the first bullet, he says that as a result of the low trading volume and unexplained volatility, quoted share prices can't be used to value it. Second bullet, it's never, Wild Bunch, which is the main entity underneath, has never made a profit. And then the fourth bullet, no financial statements since 2022, which is a sign of financial difficulties. So there's no prospect that Wild Bunch could distribute any dividends to Voltaire, which could then be used actually to repay the bonds. So there's no money coming in. And then 514, 2.2.9, he notes the problem that the claimant cannot enforce the bonds because it doesn't have 25%, and says, well, even if it could, it looks like Voltaire could not pay. And then 515, paragraph 3.1.7, the value is nil. Now, the defendant indeed it was Mr. Hussein himself, at one stage suggested that there was value in these bonds. And that was done in response to in support of the extension of time application, or one of them. And I can show you that very briefly. It's at page 1401.
Yeah, 14.
1401, paragraph 13. And he made 2 points in that paragraph. He said, firstly, he said the claimant could team up with the other bondholders, including the tenor group, and enforce the bonds. And we say that's obviously fanciful. The tenor group owns Voltaire, and they would be teaming up against themselves. And then there's the other problem, which is that there's nothing to enforce against. Wild Bunch is making losses. And then the second point he makes is he says, well, looking on a website, it says that Wild Bunch is worth $700 million. Mr. Girard addresses that point too. Page 520 of the bundle, he points out that the share price, this is paragraph 4.3.5 of his report and 4.3.6, he says you can't rely on the share prices because they're very easy to manipulate. And what you see is a declining share price and then suddenly heavy but specific trading, which punches the share price up. I don't know if you can see that graph. But the point is, if you have a privately traded company with very low trading volume, if you then trade small volumes at a high price, then it'll manipulate the price listing, and so you can't really trust these sorts of pricings for these sorts of companies, and it's really difficult to understand why the share price would rise, given that there were no accounts since 2022, and all of a sudden you've got a share price spike in 2024. So you don't need to draw any conclusions from that, other than that he's right. You cannot take anything from the share price. But fundamentally, we would say if the defendant thinks there's value in that, it can just pay the price and take the bonds. But in reality, it's worthless. So for those reasons we seek an order for €6.5 million. The other part of this is then interest. So we seek interest in two different ways. One is to say damages for non-payment of money. So under English law, and I've set out a little bit of it, if I'm owed money under a contract, and I can show that had I received that money, I would have used it in a particular way, then I can recover my losses as a result of not being able to use the money. So it's damages for non-payment of money. And effectively, it comes out as an interest award. But what we say is, well, we should have had the money a year ago, and had we had that money, we would have used it. The evidence from Mr. Gillesco is that he would have expected a 30% return on that money, and you can see that at page 39 of the bundle, and it's paragraph 83. So as I say, he says that approximately 30% on an annualized basis. That's what we could have done with that cash. So we seek interest or compensation for non-payment at that 30% rate, and I've calculated what that would amount to up to the last hearing, and I can give you an updated number in relation to that. But essentially what we're looking at is 294 days in total since they should have paid. And so depending on the rate that you wish to, I mean, the interest is discretionary. We seek 30%, but we understand that's higher than the norm. The judgment rate is 9%. For what it's worth, the bond rate was 7%. I've given some a variety of different options. EBOR is currently 4.4%, so EBOR plus 1 would be 5.5%. We do say it's justified to ask for the 30% rate because the evidence, which is unchallenged, is that that's what would have been earned. So essentially, it's just the loss of not being paid that sum. But I've, as I say, given you a calculation for that, and you can take a view on it, Your Excellency.
Yes.
Unless you've got any further questions on that aspect, or indeed any other aspect, that's all I was going to say to you this afternoon about the claim. Thank you.
No, thank you. I don't have anything. It's very straightforward, as I said before.
Thank you.
So I think this is. Do you have any submission on cost or?
Yes. So in relation to costs, I think you've got two cost schedules at the moment. They relate to two slightly different things, and they were also prepared for the previous hearing. One of the cost schedules is in the amount of $14,040, and that was in respect of an application for the extension of time, which was refused, and that's 14,040, and then the costs of the general costs of the action are in total 190,792.68. I don't have an update for you because that was the last hearing, and I'm afraid there's been another little bit. It amounts to about $30,000 approximately. I don't have the chapter and verse, but that's what I'm told, plus about $2,000 for my solicitors. So all in all, when you add all that up together, you get to $235,000, What I wasn't going to ask you to assess that necessarily. I can ask, you can assess it, of course, but I would ask for something substantial on account because we've been forced to come here. And really there's no defence that we can see. So I was going to ask you for 65% of that or something around the $160,000 mark, which is slightly more than 65%, but we would say it's justified to come up from the normal sort of rule of thumb of 50% in the circumstances. But I can help you, if I can help you with any of that, then please let me know.
I'm good for that. Anything else we'd like to hear today, or I mean, from me, I'm satisfied. But
Very good. Nothing further from me. Mr. Hussain may have something to say.
Yes, I would like to comment on a couple of things.
Yes.
Yeah, so first, Mr. Tom said, and Mr. Alex said they didn't receive any money, which to my knowledge, this is not true. They received 3 million. This is why the court hearing on March 24 was postponed till now, till the remaining money or settlement agreement with Mr. Lars is concluded. Now, unfortunately, Mr. Lars couldn't conclude it by time until today morning. I don't know the remaining amount. Mr. Alex said 2.55, but I got confirmation from Mr. Lars that it's done, and Mr. Oleg confirmed to him that this court will be cancelled, and he's done. And he is talking with his lawyers for the procedural issues, how to cancel the court and dismiss it. Now, Mr. Tom said, I am surprised. I never heard about any of this. So I would like to comment on this because Mr. Tom mentioned that he's surprised, they didn't receive any money. This is not what I heard, or what I've notified by Mr. Lars. This is one. Now, this is what I want to comment now. On the other thing of the value of the bonds, my witness statement never said that the valuation of Wild Bunch is the valuation they could, if they redeem the shares, what they could get. I said they could get something. The collateral is 3-to-1. So even if the valuation of Wild Bunch went by third, they could get the full amount. Even if it went by 6 times, they could get something. Here we're here to argue about exactly what Mr. Tom mentioned, about the example of rice. If you get something out of it, you're allowed to be ruled the difference. Now, I never mentioned in my witness statement they can get the full value of what they're asking for. We're only saying, if we give us a chance, and if you let me force Mr. Lars and Tanner to go get him the collateral, because we need Mr. Tanner, because he has more than 25%, to get him the collateral, they could get something for that bonds. That was my argument. It was never meant to say they can get the full value. We're just saying we could have been able to assign a value to these bonds, whatever it is, if we get the 25%. But we didn't have time to do that. So that was the argument. But now all I'm asking is if Mr. Oleg confirmed that if he receives 5.55, this court, he will dismiss this case and he doesn't need anything from AUDACIA. Why are we still asking for the full amount? Why is Mr. Tom still asking for full damages? I don't understand.
Yes, Mr. Tom, the claimant himself can.
Yeah, thank you. So my client is trying to tell me something, but I'll just keep that offline for the moment because I think the position is this, that what I'd understood from what Mr. Gillesco said was that the money had not yet arrived. We expect it to arrive. Now, clearly, if and when it arrives, if there is a deal, the deal will still be in place and can be executed. And of course, if there isn't a deal in place to settle this at a different sum, then the money that is received will be netted off the sum that Your Excellency orders. It's a question of execution at that stage. So for Your Excellency's purposes, as I understand it, you can enter that judgment, and then what happens next, we will wait and see. And if the money comes through, no doubt my client will honour the deal. Yes. And if they don't, then it will be for AUDACIA to come back to court and say, well, hang on, there was a deal. You broke the deal. So, and I'm sure my client will honour the deal. So I don't think that any of that makes any difference. As to the question of the valuation, there is no evidence from the defendant in relation to the actual value of what's left in the hands. And as I say, the short point is we shouldn't have to go off and start a liquidation in Holland or wherever it may be to get this money. We should just get paid the money. And if we can't sell those bonds on the market, which we can't, then in practice they're of no value to us.
Question of the 3 million received?
I can take instructions in relation to that. I'd understood that 3 million had not been received, but
I see his hand. He's raising his hand. Is it he want to say something?
Yes, if I'm Your Excellency, first time for me in the DIFC court, so apologies for any communication which may not be appropriate, but I think if I'm here as a witness, I need to state the facts right. And thanks to Mr. Hussein, representative of the defendant, mentioning 3 million euro. Yes, we should bring to light, and I think it was in the documents that we as when I say we, I'm talking about several firms that entered into different contracts. We had another contract for the option on the Wild Band shares, which was part of the agreement with Mr. Windhurst himself. So it was issued by a different company called Tenor Holding, and unfortunately Mr. Windhurst failed to pay the money on the option of that contract, and our Dutch lawyers went to Holland. I would like to stress, it was not a claim against AUDACIA. It was not a claim to replace the value of the bonds that AUDACIA owed.
Yes. I think you might have problem with the connection.
we've got problems with the connection. So yeah, I understand.
Yeah, based on that, we cancelled the bankruptcy hearing of Tenor Holding in Holland. I only would like to emphasize that by now 2 lots of bonds were traded between our broker and the London broker. The settlement is T+5.
I think we're losing.
Yeah, I'm very, very sorry about the way that this is proceeding. This is pretty unconventional approach. I'm usually told in advance of the hearing what's been happening, but my understanding of Mr. Jalesko's answer is that the 3 million that was received was unrelated. But in any event,
this is a matter of enforcement.
This is a matter for later.
Yeah. Yes. Mr. Hussein, do you have any further comments or question or?
So I just would like, I'm not familiar with the process. So can we make a stay on judgment till the 5 days happen, or no, we have to make a judgment, then we wait for enforcement?
Well, you can do anything you want later on, but this is not the purpose for now, for today, for this hearing. You can take an instruction from your lawyer, whatever you like to do, but for today's hearing is to hear the expert and to come to the conclusion about the estimation of the loss of the claim itself.
All right. Thank you.
Mr. Tom, do you have any further comments? Or?
I think you've got the points, Your Excellency. Yeah. These issues are for later. For now, all you need to do is work out how much loss my client suffered.
Yes.
And it may be that they're made good in due course by payments that are coming down the track. We don't know.
Okay, I don't have anything further from my side. If both party is already satisfied with today's hearing, then we can end this right now, and I'll do my best to issue my order as soon as I can.
Thank you, Your Excellency.
Thank you, Your Honor. Thank you.